This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Leave it to Leibowitz to lose a fair use case to the Met! Talking about the Frankenstein composite electric guitar entry. This is the online entry for a gallery exhibit, and the Metropolitan Museum of Art puts this picture of Eddie Van Halen, or rather his guitar, up on their website next to this entry. This guitar was pieced together by Eddie Van Halen from modified factory parts, seconds and mismatched parts, spray painted. It represents an effort to combine the most desirable elements of Gibson and Fender guitars, etc., etc., etc. So they put that up, and what do you think happens? We wouldn't be here if Richard Leibowitz hadn't filed a lawsuit against it. Well, the judge, Judge Valerie Caproni, immediately recognizes what's going on here and immediately orders the plaintiff to show cause why the action should not be dismissed as fair use. And that was September 18th, 2019, so last year. And so Richard Leibowitz writes back and says, well, it's not fair use. Let's take a look. He says, this is a willful copyright infringement action involving a major museum's unauthorized use of a copyright photograph of rock and roll star Eddie Van Halen. Plaintiff Lawrence Marano is a Florida-based professional photographer with decades of experience as a rock and roll photographer. Defendant Metropolitan Museum of Art, they say MMA, that means mixed martial arts to me. I'm going to call it the Met, is a sophisticated purveyor of copyrighted works. According to the Met's website, they charge admission to visit the art gallery on Fifth Avenue where the photograph is displayed. The Met displayed plaintiff's registered photograph in its art gallery and on its website without authority from the copyright holder. While they claim to have permission from Eddie Van Halen to use the photograph, Mr. Van Halen is not the copyright owner of the photograph. He is only the subject matter depicted therein. The fair use defense should be dismissed as frivolous, because the first factor weighs heavily against fair use. The first factor, which addresses the manner in which the copied work is used, is the heart of the fair use inquiry, says Leibowitz. Courts within the Second Circuit examine at least two sub-factors to determine the purpose and character of the use, including whether the secondary use is transformative or for commercial purposes. The fair use doctrine allows for new transformative works that further the public's discourse and the free exchange of ideas in order to promote science and the arts. The central purpose of the inquiry is to determine whether the new work merely supersedes the objects of the original creation, or instead adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. A photograph may be transformed, where the copyrighted work itself is the subject of the story, transforming the function of the work to a new context. Thus, a depiction of a controversial photograph might fairly accompany a work of commentary or criticism about the artistic merit or appropriateness of the photograph. In contrast, no transformation exists where the image is merely used as an illustrative aid to depict the subjects featured in the photograph. I remember we had a Good Mythical Morning story where they used a photograph of a prison to illustrate a story about the prison, but they weren't commenting on the photograph, they were commenting on the prison. So that's not a fair use. That's what Leibowitz is saying here, that they're using the Eddie Van Halen photograph to comment on Eddie Van Halen. Defendant has not transformed the original intended use of the photograph, nor altered its meaning. Use of the copyrighted material that merely repackages or republishes the original is unlikely to be deemed a fair use, and a change of format, though useful, is not transformative. A secondary use has no transformative effect where the article displays the images in the same manner and for the same purpose as they were originally intended to be used. Here the photograph depicts Eddie Van Halen playing his guitar. Plaintiff created the photograph for the purpose of showing what Van Halen looks like in performance. Likewise, MMA used the photograph to merely show Van Halen and his guitar. Further, defendant did not transform the original meaning behind the photograph, which conveys the message that Van Halen is a ground groundbreaking and unorthodox musician. Also, defendant's use is commercial. The fact that defendant used the photograph for a commercial purpose also weighs against a finding of fair use. The crux of the profit-non-profit distinction is whether the user stands to profit from the exploitation of the copyrighted material without paying the customary price. Here, there can be no dispute that defendant charges patrons admission to view plaintiff's photograph on Fifth Avenue. Regardless of whether the Met is a non-profit organization, it is still running a commercial business. After all, the Met could admit its patrons at no charge and collect money from contributions and donations. He goes on to say the second factor weighs against fair use because the photograph is creative in nature and it is the product of a professional photographer with many years of experience in licensing his photographs. Moreover, in creating the photograph, plaintiff exercised a personal and creative choice in selection of camera equipment, wide-angle lens, perspective, angle, lighting, and exposure. Leibowitz says the third factor weighs against fair use because they used the whole image. As a quantitative factor, defendant has taken the entire full-color photograph and displayed it in full scale. This fact alone weighs against fair use. As a qualitative factor, defendant has used more of the copyrighted work than necessary to accomplish its purpose of news reporting. The photograph was reproduced by defendant in full color without any visible modification or alteration. Defendant's wholesale reproduction of the photograph without any aesthetic alteration demonstrates the work's qualitative value. The fourth factor, the market usurpation factor, Leibowitz also says goes against fair use. Defendant's secondary use impairs the actual market for the photograph because there was a fully functioning market demand for plaintiff's work. Defendant's unauthorized use clearly supplanted the market in which plaintiff had a reasonable expectation to earn licensing revenue. Defendant's secondary use also impairs the potential market for the photograph because unrestricted and widespread conduct of the sort engaged in by the defendant would result in the substantially adverse impact on the potential market for the licensing of the original. In sum, the four factors weigh against the Met and their fair use defense, says Leibowitz. Let's see what the Met has to say in their defense. The Met says, as a non-profit institution dedicated to the arts, the museum has the utmost respect for artists, including photographers, and their need to protect their rights. As the College Art Association has recognized, however, in its Code of Best Practices in Fair Use for the Visual Arts, the right to make fair use of copyrighted materials is a key tool for the visual arts community, one that permits artists themselves, as well as museums, scholars, and teachers, to educate, expand knowledge, and engage in contemporary culture. Plaintiff's sole allegation in the complaint is that the museum infringed the copyright in his photo depicting Eddie Van Halen playing his Frankenstein guitar by including the photo in the museum's online exhibition catalog within its websites and in connection with the Play It Loud Instruments of Rock and Roll exhibition. This photograph. The museum's use of the photo in the online catalog is found deep within its catalog. The use is a nonprofit educational use, thus strongly favoring a finding of fair use with respect to the first fair use factor. The museum is a registered nonprofit organization, and the online exhibition catalog is free. And thus the museum's use of the photo did not generate revenue. The museum's use of the photo is also transformative, the other component of the first fair use factor, and falls comfortably within the illustrative fair uses set forth in the preamble to Section 107 of the Copyright Act, which include uses for purposes such as comment, teaching, scholarship, and research. The museum did not use the photograph for its original aesthetic purposes, which plaintiff identifies as for the purpose of showing what Van Halen looks like in a performance, but rather to illustrate the Frankenstein guitar, a work of art, in use. The photo was displayed to demonstrate that Van Halen had created a new musical sound by literally forging his own instrument, as the commentary in the online catalog suggests, and to inform the public that this groundbreaking guitar was included in the exhibition, a use consistent with the museum's core mission. Okay, so the museum also has the guitar. The museum used the photo as a historical artifact, documenting the exhibition object being played by Van Halen, a type of use deemed highly transformative by the Second Circuit. Finally, contrary to plaintiff's brief, the museum's use is more than adequate to qualify as fair use, since a defendant is not required to discuss the artistic merits of the images to satisfy this first factor of the fair use analysis. The College Art Association has specifically identified such online exhibition catalogs and similar museum websites associated with exhibits as a likely fair use, and well explains their broader purpose, saying, Online documentation of collections, including collection catalogs and databases of images and metadata, can help to place individual artworks in a larger institution or cultural context, and provides some of the benefits of a physical visit to the museum, as well as providing access to material not currently on display. Further, the fourth factor of the fair use analysis, which focuses on market harm, favors the museum, since the copyright plaintiff is not entitled to a licensing fee for a work that otherwise qualifies for the fair use defense. The museum's use of Murano's 30-plus-year-old photo in its online catalog is wholly different from the news reporting cases relied on by plaintiff, where courts often found market harm from the use of a photo depicting a newsworthy event because publishing the photo without permission essentially destroys the primary market for its use. In sum, the Second Circuit repeatedly has held courts assessing a fair use defense must engage in an open-ended and context-sensitive inquiry. Plaintiff wholly ignores the context here, instead relying overwhelmingly on inopposite case law concerning the photos by commercial media organizations in news stories or celebrity magazines. And so the judge issues her order. Plaintiff Lawrence Murano sued the Metropolitan Museum of Art for willful copyright infringement. The court ordered plaintiff to show cause why this case should not be dismissed under the fair use exception to the Copyright Act, as detailed below, because plaintiff has failed to show cause why the Met's use of his photograph is not protected by fair use. The case is dismissed. The Met included the photo in its online catalog for the Play It Loud Instruments of Rock and Roll exhibition, which examined the instruments of rock and roll from one of the most important artistic movements of the 20th century. The online catalog corresponds to the physical exhibition previously displayed in a gallery at the museum and is freely accessible. In his response to the court's order to show cause, plaintiff asserts that the Met used the photo in the brick and mortar museum as well as in the online catalog for the exhibition. That might be true, but the complaint includes no allegations regarding use of the photo at the Met. It complains only of the use of the photo as part of the online catalog. That said, this decision would be the same even if the complaint alleged misuse of the photo in the physical exhibition also. Section 106 of the Copyright Act grants copyright holders certain exclusive rights over their original works, including the right to reproduce the copyrighted work in copies or phonorecords and the right to display the copyrighted work publicly. Assuming for the sake of argument that plaintiff possesses the copyright and that the Met's copying of the photo was unauthorized, the sole issue before the court is whether the fair use doctrine warrants dismissal of the complaint. Because this action is still in the pleading stage, and because the parties' submissions are limited to the four corners of the complaint and incorporated materials, the court will apply the standards applicable to a motion to dismiss. To survive a motion to dismiss, a complaint must allege sufficient facts taken as true to state a plausible claim for relief. The court accepts all factual allegations in the complaint as true and draws all reasonable inferences in the light most favorable to the plaintiff. The court is not, however, bound to accept as true a legal conclusion couched as a factual allegation, and that's from our famous jurisdiction cases, Ashcroft v. Iqbal and Bell Atlantic v. Twombly. The fair use doctrine is a statutory exception to copyright infringement, as codified in the Copyright Act. The fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, research is not an infringement of copyright. To determine whether a particular use is fair use, courts engage in a case-by-case evaluation using 4 statutory factors in light of the purposes of copyright. Although a court must weigh all the factors, the first in particular, a use's transformativeness, is most important and has a significant impact on the remainder of the fair use inquiry. Courts generally wait until the summary judgment phase to address fair use, but dismissal of a copyright infringement claim is warranted where fair use is clearly established on the face of the complaint. The heart of the fair use inquiry is the purpose and character of the use. To determine whether the secondary use is transformative, the question is whether the new work merely supersedes the objects of the original creation or instead adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. A transformative effective use is one that communicates something new and different from the original, or expands its utility, thus serving copyright's overall objective of contributing to public knowledge. Moreover, courts have frequently afforded fair use protection to the use of copyrighted material in biographies, recognizing such works as forms of historic scholarship, criticism, and comment that require incorporation of original source material for optimum treatment of their subjects. The Second Circuit's decision in the Bill Graham case all but decides this case. The defendant in that case published a coffee table book about the Grateful Dead that contained unlicensed images of concert posters as part of a timeline of the band's history. The timeline runs continuously throughout the book, chronologically combining approximately 2,000 images representing the band's history with explanatory text. Among the images were 7 copyrighted concert posters displayed in reduced form with captions describing the concerts that were associated with the posters. The Second Circuit held that the inclusion of these posters for a historical purpose constituted fair use. The court first emphasized that the defendant's purpose in using the copyrighted image at issue in its biography of the Grateful Dead is plainly different from the original purpose for which they were created, because the posters fulfilled the dual purposes of artistic expression and promotion, whereas the defendant used the images as historical artifacts to document and represent the actual occurrence of the Grateful Dead concert events. The court next considered how the images were used for scholarship, noting that no less a recognition of biographical value is warranted in this case simply because the subject made a mark in pop culture, rather than in some other area of human endeavor. Finally, the court found that the manner in which the images were displayed in the book strengthened the transformative nature of the use. The book reproduced the posters in a reduced size in combination with textual material and graphical artwork, and the posters represented an inconsequential portion of the book. The Met's use of the photo is analogous on all 3 dimensions. First, the plaintiff and the Met used the photo for entirely different purposes. Plaintiff asserts that he created the photo to show what Van Halen looks like in performance, and that the original meaning behind the photo was to convey the message that Van Halen is a groundbreaking and unorthodox musician. In contrast, the Met spotlights the Frankenstein guitar, using the photo to reference and contextualize the exhibition object, which Van Halen pieced together himself to achieve the ultimate guitar for tone, playability, dependability, and functionality. Just as the defendant in Bill Graham used the concert poster as a recognizable representation of the Grateful Dead concert, the Met used the plaintiff's photo as a historical artifact and a recognizable representation of the Frankenstein guitar in action. Second, the Met used plaintiff's photo in a scholarly context, considering that the instruments used in rock and roll had a profound impact on this art form that forever changed music. The Frankenstein guitar is historically significant within the world of hard rock music. As with images in biographical books, museum exhibitions often incorporate other source material for optimum treatment of their subjects. Plaintiff's photo is displayed on the biographical page for the exhibition object, the very instrument depicted in the photo. In other words, they have the guitar, and this is the page that is describing the guitar, and there's a photo to go along with it and showing how it's used. The very guitar that spawned legions of copies and inspired generations of fans to design their own instruments. Plaintiff argues that the Met's use is not transformative because the exhibition does not critique the artistic merits of the photo itself, but merely uses it as an illustrative aid to depict the subjects featured in the photo. His argument misunderstands the nature of the inquiry. What is relevant is not whether the exhibition comments on the photo per se, such as the photographer's choice of lighting or focus, but whether it uses the photo to help illustrate the historical and artistic significance of the guitar, a separate and distinct purpose from the photo's original expressive purpose, which was to illustrate Eddie Van Halen. Going back to the Good Mythical Morning example and the prison photo, this is a little bit like if Rhett and Link had used the photo to describe something other than the prison. So in other words, the photographer took a picture of the prison to represent the prison. So if Rhett and Link had said, we need to show you what trees look like in Norway, we're going to use this photo of the prison. That's probably a fair use. Do you get it? Does that make it a little bit clearer?
Holy crap, that's really interesting. Man, our knowledge of copyright expands all the time, right? Like,
yeah.
I remember that we had a big argument about this back during the Mythical Morning thing, and then right after we had the Area 51 raid.
Yep. And I didn't want to use Area 51 footage because I wasn't making a fair use of it, I didn't think.
Right. But like, this is really interesting that it's not categorically the case.
Right.
That you have to be like commenting on the video.
Right.
I think the fact that this is a museum that is trying to talk about historical significance of something in their exhibit is also different than if you were a media or news company, because all of the examples that Leibowitz had cited to were for media use of an illustrative thing. So the fact that it's a museum, it's a nonprofit, it's for educational purposes and historical purposes, gives it a different flavor.
Yeah.
So if they were using a poster, to extend the example, if they were using one of the old posters to promote a new concert by the same artist, would that be copyright infringement if he didn't have the rights to it?
Yeah, probably. Yeah. Because you're using it for a similar purpose. The poster was created to promote the original concert. So promoting a concert is definitely the same purpose and character and is not transformative. But if you say use the poster in a mosaic, and then you zoom out and the mosaic reveals another poster. Well, that's pretty transformative. I might rule in favor of fair use on that one, but that would be closer to on the line. Third, the photo constitutes an inconsequential portion of the Met's online catalog. Plaintiff's photo is a single image surrounded by pages of navigable textual, visual, and audio content. The photo is located several page clicks within the actual catalog of 185 object pages. And even on the Frankenstein Guitars page, the primary focus of which is historical and descriptive text and photographs of the guitar, the photo is almost an afterthought. In short, the online catalog's layout is designed to enrich and elaborate the guitar's historical significance. In evaluating the purpose and character of the use, the court must also consider whether such a use is of a commercial nature or is for nonprofit educational purposes. The commercial nonprofit dichotomy concerns the unfairness that arises when a secondary user makes unauthorized use of copyright material to capture significant revenues as a direct consequence of copying the original work. Plaintiff argues that because the Met charges a general admission fee to out-of-town visitors to the museum, it is a commercial enterprise, and therefore the use at issue is commercial, notwithstanding the Met's status as a nonprofit. While discovery might be helpful in providing additional information about the Met's revenue structure, or how profitable this particular exhibition is, the relevant issue is not the Met's business model, but whether the use at issue is commercial in nature. Even in the unlikely event that discovery would reveal that plaintiff's photo drove viewers to visit the Met's galleries and pay admission fees, the court would not place much significance on that fact due to the transformative nature of the secondary use. In short, the first factor strongly favors a finding of fair use. The second fair use factor considers whether the work is expressive or creative, with a greater leeway being allowed to a claim of fair use where the work is factual or informational, and two, whether the work is published or unpublished, with the scope for fair use involving unpublished works being considerably narrower. The photo is indisputably creative and published. While ordinarily the creative nature of the photo would weigh in favor of the copyright holder, the secondary factor has limited weight in this analysis because the transformative purpose of the Met's use was to emphasize the photo's historical rather than creative value. The second fair use factor weighs minimally, if at all, against a finding of fair use. The third factor asks whether the quantity and value of the materials used are reasonable in relation to the purpose of the copying. Copying the entirety of a work is sometimes necessary to make a fair use of an image. Thus, the third factor inquiry must take into account that the extent of permissible copying varies with the purpose and character of the use. While the photo is displayed in its entirety, such use is reasonable in light of the purpose and character of the use. The Met uses the photo as a historical artifact, providing visual context for the exhibition object and the accompanying factual information about the object. In order to achieve this purpose, it is reasonable that the Met included the full picture of Van Halen playing the Frankenstein guitar. Moreover, the Met reduced the size of the photo and mixed it with text and other photos, limiting the visual impact of the one photo's artistic expression. In this case, the secondary use was limited and focused on the historical nature of the photo. The third factor thus does not weigh against a finding of fair use. The final fair use factor is the effect of the use upon the potential market for or value of the copyrighted work. This analysis is concerned with whether the secondary use usurps the market of the original work. As with the other factors, this factor is also influenced by the resolution of the transformativeness inquiry, because the more transformative the secondary use, the less likely the secondary use substitutes for the original. The Second Circuit has made clear that a transformative market does not qualify as a traditional market. Plaintiff argues that museums are a potential market for his work because they are shifting towards more modern, pop culture-centered exhibits. But plaintiff cannot prevent others from entering fair use markets merely by developing or licensing a market for transformative uses of his own creative work. A traditional market for the photo would be collectors of photographs of rock legends or other persons seeking to showcase Van Halen. Being generous, that market might even extend to museums exhibiting musicians. But the Met's use of the photograph to visualize the Frankenstein guitar as played by Van Halen falls into a different transformative market. It is thus unlikely that markets for the photo's original expressive purpose would be affected in any way. In any event, plaintiff has offered only conclusory assertions that the Met's use has caused a meaningful or significant effect upon the potential market for the copyrighted work. Accordingly, the fourth fair use factor weighs in favor of finding fair use. The court finds that the balance of the fair use factors strongly favors the Met's use. The first and most important factor heavily weighs towards a finding of fair use and significantly colors the other three. The Met's use of the photo to represent the Frankenstein guitar as a historical artifact is transformatively different than the original expressive purpose of the photo. The second factor, which might otherwise favor plaintiff, therefore, has limited weight. Similarly, although plaintiff's photo was copied in its entirety, the third factor does not weigh against fair use because the amount of the photo used is reasonable in light of the transformative purpose for which the photo was used. Finally, plaintiff's appeal to missing revenue in the museum's market holds no sway and in fact favors a finding of fair use. For the foregoing reasons, the court concludes that the Met's use of plaintiff's copyrighted photo in its online catalog is fair use. Accordingly, plaintiff's complaint is dismissed. The clerk of court is directed to close this case, and that's Judge Valerie Caproni, United States District Judge for the Southern District of New York. So that's really remarkable. Leibowitz continues to file cases that have no merit. You should not have filed a case against the Metropolitan Museum of Art for displaying one of his client's photos. I just, even if they just plastered his photo on the wall, I still can't imagine why I would think it would be okay to sue an art museum. I mean, it's like suing a library. Okay, the Internet Archive thing, that's a little bit different, but I mean like a genuine, brick and mortar library, you wouldn't. It's just stupid. So why Leibowitz thought that he would get a quick settlement out of that, I don't know. Why he thought that if he didn't get a quick settlement that he'd win the case, I don't know. Why Leibowitz? I don't know. Don't be a Leibowitz. All right, that's our show, everyone. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel on YouTube, Twitch, and Floatplane. This is a community-supported channel. We would not exist without your financial support on a monthly basis on patreon.com/ljfrench and sponsors.com/law. Special thanks in the month of July to BU number 1 Simmons for supporting our channel. Thank you to our July $50 plus supporters, Nicely Done Defense, Joe Tyson, Wes Delge, Citizen of the Sovereign, John Steele, Gavin Barnard, Evie, Kyle Mudrock, Spirit Bear, Jan DeGray, Michael Pierce, Daniel Perez, Blackleaf, Benjamin Hightoff, Steven, Cute Grills in Your Area, Strawberry Pup Tart, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shiloh T, Gregory Conklin, Josh Baker, Rudolph Bescherer Jr., Oscar the Prophet, Jay Dixon, Hot Grills in Your Area, Ammonite, and Brandon Abel. And thank you to the July $5 plus supporters who are in the description of the video below. I love you all. I really am thankful for all of your support. We really would not be able to do this without you. Have a good one. I'll see you hopefully next time from Luxembourg. Bye.